Welcome back again to our lessons on the judicial system. This time we were looking at the Supreme Court, Part 1. This is the first part of a two-part lesson on the Supreme Court, kind of a big topic. We want to be digging into this, so we're going to take a couple lessons to do so. All right, the Supreme Court. Now, all courts can determine questions about the Constitution. This is what the federal court system does. It interprets what the Constitution intended for our nation. But none of the decisions are final except, well, not really even the Supreme Court, but the Supreme Courts are the most final. Only the Supreme Court decisions can set a precedent that can't be challenged. Okay, so if the Supreme Court makes a decision, that is a final decision unless a couple of things happen. One of which is another Supreme Court can overturn a past decision. This does happen sometimes. Also, a constitutional amendment can be made, which is not really a reinterpretation of the Constitution so much as a rewriting of the Constitution. But all that being said, the Supreme Court precedents, all cases that are close to that have to be followed by all court systems. That's the way our system works. Now, one of the most important powers of the United States Supreme Court is judicial review. Judicial review is what allows our United States Supreme Court to determine the legality of laws. Are the laws themselves legal laws? Did Congress have a right to pass that law? They also determine the legality of executive actions. That is, did the President of the United States have the constitutional authority to act in the way that they did? Now, here's a catch with judicial review, and it's important to know. It doesn't actually exist in the Constitution. The United States Constitution did not give the Supreme Court the authority to determine the constitutionality of things. But this right and this power was established early in U.S. history. Early in U.S. history, we said, well, why do we have a Supreme Court if not to do this? That precedent was established in the case of Marbury versus Madison. There are a few Supreme Court cases that you do need to know. This is one of them. Marbury versus Madison. In this case, in 1803, William Marbury sued the Secretary of State, James Madison. James Madison was sued by this individual. James Madison is a member of the federal government, a member of the executive branch, who refused to give William Marbury an appointment that he had been granted by the previous president. Now, the Judiciary Act of 1789, remember that one from last time, stated that lawsuits against the government, against government officials, should go to the Supreme Court. Okay, one more time. This law of Congress said that if a government official is sued, that should go directly to the Supreme Court. It should bypass district courts and appellate courts, go straight to the Supreme Court. But the Constitution said nothing about that. And what the Supreme Court did was a very interesting thing. The court ruled that part of the Judiciary Act was unconstitutional, that the Supreme Court did not have the authority to hear this case because the Constitution did not give them the authority to hear this case. That was an interesting thing that the Supreme Court did. They said publicly, we don't have this power. But by saying that, they were granting a bigger power to themselves. That is the power to say that Congress, a part of your law, is illegal. And once they establish that they can declare a law to be illegal, unconstitutional, that was the greatest power of all. That is judicial review. All right, justices. Now, the Constitution of the United States doesn't list any qualifications to be on the Supreme Court. Okay, it's not like we saw in the House of Representatives where you have to be 25, or Senate where you have to be 30, or President where you have to be 35, or different levels of citizenship, or where you were born, or how long you've been in the United States. We don't have any of that. It's not there for the United States Supreme Court. And on top of that, a justice serves for life. So if you are appointed to the United States Supreme Court, you are there for the rest of your life. It is a lifelong gig, or until you get impeached or you choose to resign. However, you must be approved by the United States Senate. So here we have that checks and balances in play. The president appoints them. The Senate has to confirm that appointment. Now, very few people are actually considered qualified to hold this job. It's an extremely important job that you will have, in all likelihood, for 25 to 30 years. People generally get appointed to this position in their 50s, 40s or 50s, and then live into their 80s. So you have to be very qualified for it. It's a very important job you have for a long time, and no one can take it away from you. So when a president gets one of these appointments to make, and generally a president is going to get one or two of these appointments, you don't generally get more than that. The president has to choose carefully and choose a very qualified individual. All right, changes among justices. Since 1789, the U.S. has had 117 justices on the U.S. Supreme Court. At any point, there are 8 associate justices and 1 chief justice. That is the ideal number, the number that we've had for quite some time now, 9 justices on the court. All but 11 of these justices have been white, male Christians. So do keep that in mind, that we have not been the most diverse group within the Supreme Court, although things are getting more diverse and more representative today. Today there are 3 women on the United States Supreme Court. There are 3 Jews on the Supreme Court. There's 1 African American, and our first Hispanic justice in U.S. history are all on the Supreme Court today. So it is a more diverse organization than it has been in the past. All right, the working of the United States Supreme Court. The decisions of the 9 justices can affect the nation for decades. They make a decision, and all courts have to follow that decision. Congress has to follow those decisions. They are as powerful as the Constitution itself. And it is important that all of those decisions are very fairly and carefully considered by our justices. So, what do they hear? What do they decide? Well, certain cases have to be heard by the Supreme Court. These are the ones that they have original jurisdiction for. There are also ones that they may hear based upon appeals. These include appeals from federal laws and cases that come directly to the Supreme Court. The court receives a lot of requests. There are about 8,000 appeals every year. That is 8,000 times coming from the appellate courts, those circuit courts. Somebody will say, I don't like this ruling. The Supreme Court is going to decide this, and they appeal their case to the United States Supreme Court. The United States Supreme Court is not going to hear 8,000. They hear about 100 cases per year. That's a typical caseload for the United States Supreme Court. 100 cases out of those 8,000. The rest, they simply say, do you know what? Whatever the appeals court said, that's going to be the answer. Too bad, so sad. That's how it is. Now, hearing arguments. The justices of the United States Supreme Court first study a brief. This is a written summary of the arguments made by both sides of the case. Okay? They summarize the arguments, submit it to the justices, and the justices are going to read those. They do that for an awful lot of cases. This is not the ones they accept. These are the ones that are appealed. But once the case is accepted and you've read that brief, reviewed that brief, the attorneys for the accepted cases, now we're talking about the 100, are called into the Supreme Court, and they each have 30 minutes to argue their side. 30 minutes, that's it. You get 30 minutes to argue your side. And then you have a question and answer session by the justices. This could go 2 minutes, this could go 2 days. We don't know how long the question and answer section of a case may last. Sometimes they do last quite a long time. Now, once they have heard the case, they've had their questions answered, the justices are going to meet to decide the case. So they go sit down in a room. It's just the 9 of them. No one knows what they decide. They don't even tell the President of the United States. Nobody knows what they have decided until they decide to release that opinion. The Chief Justice will sit down at this meeting, and he'll summarize the case. And the Chief Justice gets to be the first to offer their opinion. So they will be the first to say, I think that we should rule in favor of so-and-so because of this. That's the power of being the Supreme Court Chief Justice, the right to be heard first. Then when all other justices have shared their thoughts, the Chief Justice calls for a vote. The side with the majority wins. We have 9 justices, so 5 is what you need to win the case, and that is how a decision is made within the Supreme Court. Once that decision is reached, a couple of things still need to be done. Number one, we have a majority opinion. That is a time where the opinion of the majority, the opinion of the 5 justices who voted on one side, is going to be written out explaining the court's ruling. Why did they rule the way they did? How should the Constitution be interpreted in this case and perhaps in any other case that is similar to this? And in this majority opinion, justices have a tremendous amount of power. They're not writing law, but they are writing the interpretation of the law that must be followed, and it must be followed. Now, a justice who agrees with this decision, but not for the same reasons, could write a concurring opinion. They could say, the majority got it right, but for the wrong reason, and this is my opinion on the reason. That opinion does not have the force of law. The majority opinion has the force of law. Concurring opinions do not. Another one that does not have the force of law is a dissenting opinion. A justice who disagrees and disagrees strongly with a majority opinion might write a dissenting opinion. Now, you might ask yourself, why write a concurring opinion? Why write a dissenting opinion? These are labor-intensive, long documents that take a lot of time and effort and don't have any direct impact. Well, they kind of do. Justices write these in order to influence future courts. In case a case like this were to come to the Supreme Court again, and they were wanting to re-debate this issue, they could look back to the concurring or dissenting opinions for evidence that supports the more modern ruling. That's why those are written, and that's how the cases are heard. Now, we're going to dive more into the Supreme Court and what happens with these decisions in our next lesson, but that was all for today. Thank you very much for joining me. I hope you learned something, and farewell.